yay, oh yay, oh yay, this Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning, everyone, and welcome. We're very pleased to have you with us today. We have 3 cases on the morning docket, and we will hear them in the order in which they appear. Let me remind counsel that each side has a total of 15 minutes for argument, meaning that if there's 2 or 3 appellees, you will have to share that time. Each of you don't get 15 minutes. The appellants have the right to reserve up to 5 minutes for rebuttal, so when you come to the podium, after you've introduced yourself, please let us know how many minutes you wish to reserve, and we will program the clock accordingly. Are there any announcements or introductions? Hearing none, please call the first case.
Loren Probst et al. Versus Liberty Mutual Group Incorporated et al.
Good morning, Mr. Winter.
Good morning, Your Honor. Good morning, Your Honors. I am Gus Winter of the Nashville Bar. I represent the plaintiff appellants, Loren Probst and Daniel Staken. The question presented to the court this morning is under a de novo review. And the question is whether the plaintiffs suffered a bit of buyer's remorse and attempted to back out of an enforceable settlement agreement, or whether, on the other hand, the defendant insurer failed to produce and submit an authorized settlement release agreement by the March 14, 2022 deadline that the defendant's counsel himself had set. I really would like to just focus in on 2 documents that I think will bring this dispute into context. And the first is a March 8, 2022 email that Liberty's attorney, Mr. Neal, sent to the other parties in this case. It's Exhibit 7, and it appears at page 160 in the technical record. And what this document does is it provides the court with a snapshot of where, according to Mr. Neal, the parties stand at that. Oh, I'm sorry, I forgot. I would like 5 minutes time to
right,
reserve for rebuttal.
5 minutes. Thank you, sir.
The snapshot email from Mr. Neal states that as of that point in time, he had previously submitted a January 28, 22 proposed settlement agreement, which he says at that point the plaintiffs have not agreed to accept. And then Mr. Neal goes on to describe that he has a counterproposal in mind, and he describes in this email what he generally thinks the term should be. And then he draws a line in the sand. He states that due to the passage of time, it doesn't appear that there's an agreement on either the January 28 proposal or his new counterproposal. So basically, at this point, according to Liberty, there's no agreement. But he says that the parties will have until March 14 for the plaintiffs to either sign off on the January 28 proposed settlement agreement or accept Liberty's counterproposal. What happens after that is presented on its Exhibit 10, page 165. This is another email from Mr. Neal to the parties. And in the interim, there had been evidently communications, and there's emails between the lawyers that suggest that there is an agreement and question about who's going to write it up. But there's a snag. When the settlement release agreement comes in on March 17 from Mr. Neal, 3 days late, what he says in his email is, I'm still awaiting final approval from Liberty regarding the revised language. In an effort to keep this process moving, I share this language with you in case you have any changes. So this is not authorized. And As I've cited in my brief, there is an old Tennessee Supreme Court.
How do we know it's not authorized?
Because he says so. He says, I'm still awaiting final approval from Liberty regarding the revised language. And he says he's sending this proposed settlement release agreement to keep the process moving. When this is not something, if the plaintiffs had attempted to enforce this agreement at this point in time, they wouldn't have been able to do it because the insurance company was not bound by it. And that's the Barina case where...
So why didn't the attorney for the insurance company have apparent authority to settle as part of the earlier email communications before the 17th? I mean, isn't it possible here the attorney is just wrong on the 17th with the idea that this is still open, that Liberty could still back out of this, that he's already agreed and he's acting with the apparent authority to reach a settlement?
Well, respectfully, I don't believe it's apparent authority if he says he doesn't have it. And from the standpoint of the folks on the other side, they can't construe this email as him being able to bind it.
Prior to the 17th, though, in the email communications, and you mentioned, and there's a couple places in your brief where it sounds like there is an understanding reached on the 14th of March, or by the 14th of March. And then the 17th, the attorney says, well, you know, I still have to get approval from Liberty, by the way, of this language. But didn't we already have an agreement on the 14th, or by the 14th in this case, to settle this case? And then the attorney in error on the 17th essentially thinks that he could still back out. Counsel for Liberty thinks he could still back out?
I think the record supports the argument that the attorneys, or at least presumably the plaintiff's attorney and the attorney for the other defendant, Blues, assumed at this point in time that there was a deal. But the attorneys for the plaintiff learned on the 17th that that was not at all the case. And at that point...
Well, on the 17th, weren't the attorneys, in effect, adding parts to the deal? A deal had been reached, and the attorneys were saying, oh, in addition, we want these assurances that no money is going to be sought after our clients, and we want to make sure these other parts are in place. But there was a deal on other components, and it seems like to me that is sufficient to form an agreement.
Well, and that, Your Honor, is really why I started with the preceding email from Mr. Neal on the 8th, which basically clears the decks and says, as of this point in time, there is not a deal. And the next thing we hear from Mr. Neal in terms of what should be touching home plate on March 17, or should have been the 14th, but on the 17th, when he presents the document, he says, this doesn't give you the power to enforce or nail down an enforceable contract because I still have to get approval from my client. And that means they failed to meet their own deadline. Mr. Neal is telling the attorneys that his client is not bound, and under Canton Cotton Company case of the Supreme Court in 1924, if one party is not bound, the other party is not bound. And if that's the point, and I'm running out of time, but that's the point, Your Honor, where certainly the plaintiffs had a right to withdraw from the negotiations because all Mr. Neal was doing was continuing to kick the can down the road. He didn't give Mr. Lewis, the plaintiff's attorney, the power of the pen. He didn't give him a document that Mr. Lewis could sign and say, done.
Counsel, the authorized settlement agreement before the expiration of the deadline, the issue that you framed here in your brief, was that raised before the trial court? Was that argument raised before the trial court in this case? And the waiver's been argued by opposing counsel in this case.
Yes, and it appears both, and there are different lawyers and there's different phraseology, but Mr. Jenkins's brief states, he cites the Barina case, which is directly in point with the argument I'm making here, and that is that the attorney cannot bind his client to something that the client has not agreed to. And what we have here is Mr. Neal, and this goes to your Honor's question earlier, Mr. Neal could not bind his client on March 17 to something the client hadn't authorized him to agree to.
Is that argument within the scope of the issue that you've presented in your brief on appeal? Is the argument with regard to the authority to bind, does that, because you're stating the issue as whether the plaintiff's insured can be held to a conditional settlement agreement after the defendant insurer failed to submit an authorized settlement agreement before the expiration of the deadline set by the insurer. Is the argument you're making here that you just made, is that within the scope of that issue that you've presented?
Yes, it is, Your Honor, and I would also point the court to Mr. Jenkins's oral argument, and it appears at page 12, where he states that there was no communication from Mr. Lewis after he was advised on the 17th that the offer was not authorized. There, again, the language is not...
Mr. Winter, that's a different issue. The appellees insist that you're raising a single issue on appeal, and they insist in their brief that it was not raised in the trial court. In your reply brief, you responded to that by saying Mr. Jenkins raised it, but I didn't find a citation to the page, and now I hear it's page 12.
Yes, sir.
But the response to the motion that Mr. Jenkins filed, conclusion, page 2, plaintiffs did not agree to settle on the terms that defendant now seeks to enforce, and prior counsel had no express authority to accept the same. Absent a meeting of the minds, the motion must be denied. Then on page 13 of the transcript at the hearing before the judge on August 18, Mr. Jenkins says, I would submit my client's position is that they did not agree to the material terms and that Mr. Lewis did not have the authority to agree to the material terms, but that this agreement does not represent it. They are not waiving that privilege, Judge, and so I'm limited as far as what else I can say. But the issue you raise on appeal is there's a condition subsequent. They're not the same.
Your Honor, I submit, I respectfully disagree. And again, at page 12 and 13, he says, Mr. Jenkins is specifically referring to the email of the May 17, March 17, excuse me, where he says, I'm not going to agree to this. I'm just sending this to help speed things along. That's what I'm referring to. And then he says at some point that his client actually agreed to it. But what Mr. Jenkins points out and tells the trial court is there were no communications with Mr. Lewis after that. There was no communications after it. I submit that leaves terms open. So what he's talking about was that document was not a final expression, and then his clients were free to walk away from it.
But your issue is based upon the defendant insurer failing to submit an authorized settlement agreement before the expiration of the deadline.
Right, and that's exactly what Mr. Jenkins is talking about at that point.
Mr. Jenkins says they did not agree to the material terms and that Mr. Lewis did not have the authority to agree to the terms.
Right.
Those aren't the same thing.
Well, Your Honor, what he was referring to was from the very first back to December when Mr. Neal first sent the first settlement release agreement, and he advised Mr. Lewis that it was going to require a subsequent document. That is, a document that was going to have to be a settlement release agreement approved by the insurance company. They didn't have that. That's what Mr. Jenkins is talking about. This has to be taken in context with the conditions for an acceptance on the part of the plaintiffs. They were going to have to sign a document. That was a missing term in terms of what happened and what was received on the 17th and it was not the authorized settlement release agreement that Mr. Neal had told the parties, told the plaintiffs back in December was going to be required.
All right, thank you. We'll hear from you further on rebuttal. Good morning.
Good morning. I'm Gary Grooms, and I represent Liberty Mutual Insurance Company, one of the two defendant appellees in this case. Mr. Mangelsdorf represents Blues Limited, and we have agreed that of the 15 minutes allotted to us, I will use 10, and he will reserve 5 minutes.
Very good. Thank you, Mr. Grooms.
Your Honor, plaintiffs have appealed an order from the Marshall County Chancery Court that enforced a settlement agreement reached by the parties. The basis for plaintiff's appeal is their contention that there was a failure of a condition subsequent that they have identified as a condition that required Liberty to submit a settlement agreement by March 14, a deadline that they say Liberty's counsel set by himself. That argument fails for two reasons. One, it was not raised in the court below. Respectfully disagree with the opposing counsel's statement that it's just a, quote, different phraseology. It is entirely a different issue that was not raised at all in the court below. But even if the plaintiffs had raised that issue in the court below, it would fail for the simple reason that there is nothing in the record that suggested that plaintiffs' acceptance of the settlement was conditioned upon submission of a settlement agreement by March 14. Your Honor, since I only have 10 minutes, I might want to come back to the details of the formation of this contract. It's a lengthy chronology that both parties have recited in their briefs.
Counsel,
but I do want to start.
Before you move on from that,
yes.
At what point, the Chancellor here seems to have set the date here as March 17th. That there was a, March 17th is when we have an agreement in this case. At what point do we have an agreement on the 14th in this case? Is there an agreement earlier than the 17th, or and where would you place it in terms of where our initial agreement
Sure,
or
Your
earlier
Honor.
agreement is?
And we argued in the trial court, we asked the trial court to enforce either the first agreement that the parties reached in December of 2021, or in the alternative, the agreement that was reached in March after the parties had
and that's by March 14th?
Yes, March 14th. But we say, and we argued before the trial court, and we argue today, that there was an agreement reached in December.
And so Liberty, you would accept that Liberty was bound by that point?
Yes.
Your client, okay.
Absolutely. And the reason is there's a first offer made on December 17th of 2021. Actually, a demand made by plaintiffs. Mr. Neal wrote back on December 17, and that his very lengthy email is attached as Exhibit 1 to the motion to enforce the settlement agreement. It's not the kind of email that lawyers usually send. Hey, will you take X dollars to settle the case? It is a two-pager that contains very detailed terms of the settlement along with the settlement amount. And Exhibit 2 was the response received the same day from the plaintiffs, that they say, we agree, subject to confirmation that Blues, who had done some remediation work after the loss, wasn't claiming any additional sums, and that Liberty wasn't either. Well, Exhibit 3 to the settlement agreement is an email from Counsel for Blues Limited saying, we agree. You don't owe us any money. Liberty had never made any claim that they were owed any money. So there's a settlement reached on December 17 when the plaintiffs wrote back the same day and say, we agree with the terms subject to these two caveats which both Liberty and Blues agreed to. So under I think the established case law, once parties have reached the essential terms of a settlement agreement, at that point there were no outstanding issues. Those issues only came up when Mr. Neal then submitted a settlement agreement, and that settlement agreement was sent on January 28th, and it's Exhibit 4. Plaintiffs wanted the agreement that they had reached that no other money was owed. They wanted that expressed in the agreement, and they wanted a non-disparagement provision to be mutual. Parties agreed to that. There was never any refusal to make the mutual disparagement agreement or to make the non-disparagement mutual. Well, then there was some frustration. Mr. Neal wasn't getting any traction with the other side and getting the settlement agreement finalized, so we sent the email that opposing counsel places great weight on, that email of March the 8th. But what he says is this, not exactly as opposing counsel characterizes it. He begins the email by saying, from Liberty's perspective, the parties agreed to a settlement in December 2021. That's his first statement. And then he goes on to talk about how the parties had requested some minor changes, these issues arose, and they resolved them with the submission of the settlement agreement that he then sent. The March 8th email says, we've got to have an agreement on these issues by March 14, or Liberty is we're going to withdraw. We're not going any further. We've got to bring this to a head, and we got to resolve these by March 14. Well, they did. On March 14, counsel for the plaintiffs sent an email saying, where do we stand on this? Blue sent an email saying, we agree to the terms of the settlement. And then Mr. Lewis sends an email saying, do you want to draft these or do you want me to? So how can how can they possibly argue that the differences that had arisen in those very minor things in the settlement agreement were not resolved by March 14, when Mr. Neal and the parties all exchanged an email saying the case is settled? So I want to jump quickly to the issue of waiver. They argue that they really raised this issue in the court below. In the court below, as Judge Clement noted, they raised two issues. They raised the authority of the attorney to bind them to a settlement, and they said that our attorney was not given actual authority to agree to all of these terms. It's important they never identify the terms that they didn't allow their counsel to agree to. Not once, even in the court below or here, have they said, we didn't authorize our attorney to agree to point A, B, or C. They just say he really wasn't authorized to agree to everything that he agreed to. And when they responded to the motion to enforce the settlement, the judge pressed them on that, and Mr. Lewis kept saying, I'm really kind of hamstrung by the privilege. My clients haven't waived the privilege. I can just sort of baldly say, well, I didn't really have the authority. And the court said, well, without any more evidence, you haven't put any evidence in about what authority you had. I can't accept that argument. And then they said, well, there really wasn't a meeting of the minds. And they argued there's no meeting of the minds because the email that Mr. Neal sent back in December, the very detailed email, ended by saying, but we've got to enter into a settlement agreement that will contain these and other terms. And they argued that wasn't definite enough. Well, the court really had a little difficulty in saying, this is a pretty detailed term sheet, and you agreed to it, and that's a settlement, and you've given me no evidence that the attorney lacked the authority to agree to it. So the court enforced the settlement. Now, here they argue that, unlike what they said in the trial court, we never reached an agreement. They say here, we had an agreement, because the only way that you can have a condition subsequent is if the party has an obligation to perform, and the obligation to perform is not fulfilled. So if there was no settlement agreement, then nobody had any obligation to perform. And the second reason the argument fails is that even if they had raised it in the court below, there's absolutely no evidence in the record showing that plaintiffs ever conditioned the agreement that they agreed to first in December, and then after all of these other issues had been worked out in March. There is nothing in the record that says that their obligation to perform that agreement was conditioned upon submission of a settlement agreement by March 14.
Is the statement of the issue that's presented for review broad enough to allow this court to consider whether there was a meeting of the minds in this case, or is the language, the authorized settlement agreement language, too narrow to allow for consideration of whether there was a meeting of the minds, separate from that question of the settlement agreement itself?
Yes, I don't think so, Your Honor. And the reason is, as I said, they're very different, conflicting issues. The statement of the issue that they present is whether the plaintiff insureds can be held to a conditional settlement agreement after the insurer failed to submit an authorized settlement agreement before the expiration of the deadline. And they describe further in the brief as a condition subsequent. So their argument is, we had a conditional settlement agreement. We had a settlement agreement, but it was conditioned upon you submitting an authorized settlement agreement by this date. And respectfully, I don't believe that the court can look at that email exchange between the parties and see that that was ever a condition imposed either by plaintiffs or by Liberty. The condition was only that we got to reach an agreement by this date because this has dragged on far too long.
All right. Thank you, Mr. Grimes.
Thank you, Your Honor.
Good morning.
Good morning. If it please the court, my name is Chuck Mangelsdorf of the Nashville Bar. I represent Blues Restoration Limited, which is a franchisee of ServPro, and their job was to come in and clean up the water damage that was suffered by the Probst and Staken homeowners. Your Honor, Your Honors, I believe we should just step back a moment and look at the procedural status of how we got here today. It seems to be clear from our view of the facts and the emails that were exchanged, both in December, January, and then in March, that really none of the essential terms of this agreement were ever changed by the parties. And the court, I would remind the court, as we've cited to Tennessee jurisprudence and the black letter contract law that the judge in Marshall County had to review as well, that this purported agreement signed and then notarized by all the parties and or their lawyers is not necessary because, as the court well knows, once cases get settled, and they get settled every day on email exchanges and or phone calls, that's the agreement. That is the agreement that the parties are bound by. And then, as stated in the Gurley case and other cases, this later settlement agreement that is put together to include all the laundry list of terms, including often boilerplate, that's never even really discussed, the essential terms have already been agreed to and are enforceable by the oral agreement of lawyers who have apparent authority to bind their parties. Unlike almost any contract that is normally done, when lawyers are involved with the contract, they are the apparent agents and have the authority to bind their clients.
Opposing counsel has referenced an email on March 17th that seems to suggest some limitation with regard to liberty and authorization. Is the agreement in this case actually reached before the 17th? Is this the right date for thinking about when this agreement was reached prior to March 17th?
Yes, Your Honor. I think that is because the essential terms really never changed. There was an amount of money to be paid. This is a lawsuit all about money, damages, and those were the essential terms. They were agreed to. This is classic, I believe, buyer's remorse, because what's interesting is when we get through all these other emails and there is delay, it's kind of unexplainable. I'm trying to remember back last night why this did take so long. But none of, even throughout these months and these various emails, you have the plaintiff's attorney at one point trying to get more traction on March the 7th and just reminding both of the defendants, hey, when are we going to get our money? What's the delay? And then these little, we'll say, minor sort of back and forth on non-disparagement and my client not seeking any money in the future. Those are not really the essential terms of the settlement, we argue. And what's interesting is once Liberty's attorney went ahead and sent the agreement over, what happened was As I state on page 11 of our brief, upon receipt of that memorialized agreement, again, basically memorializing December agreement plus the add-ons, upon receipt of that memorialized agreement, plaintiffs suffered from buyer's remorse, substituted their attorney, and then did nothing. They did nothing. They sat back and refused to sign. So our clients, I guess out of an abundance of caution, we advise our clients, well, until it's signed, let's just hold on to the money. And then nothing happened until August when our clients were forced to file a motion to enforce settlement. It was well supported by the record. The chancellor looked at it, and he made the comment in his ruling, quote, I think it's contract 101, except for the fact that I don't have their signatures. I mean, it's that simple. And we submit that it really is that simple. Every day, lawsuits are settled on emails by attorneys, or oral agreements that are then put in an email. And those are binding on the parties. And to let a party that may be having communication issues with their third attorney then back out of it, it's just, it's not what the law envisions. And we submit the chancellor was right, and there's not enough on this side of the argument to overturn what the judge did on our motions to enforce the agreement. Thank you.
All right, thank you, Mr. Mangelsdorf. Mr. Winter, your rebuttal.
In terms of, I'll make 2 points. One, in terms of the December 17 document, which defense counsel has referred to as an agreement, it really wasn't, because although Mr. Neal referred to it as something that had been agreed to, when he changed it before he sent it to plaintiff's counsel. If the court will recall, when Mr. Lewis indicated that he was inclined to accept the agreement, he said, well, but oh, by the way, there are 2 other points, and he mentioned that that the party's house had been sold. So Mr. Neal then attempted to rewrite the agreement to address for that undiscovered or unknown event, and then Mr. Neal took the liberty of inserting non-disparagement clauses as to the plaintiffs only. So that was a new agreement, or a new proposed agreement, that was never accepted. The plaintiffs could have signed that one and sent that in by March 14, but they chose not to do that. And second, the terms that I submit that Mr. Jenkins was referring to in his brief and in his argument before the trial court were again attached to what Mr. Neal had told the parties, told the plaintiff's counsel at the beginning of the settlement negotiations, that it wasn't going to be agreed to by emails between the lawyers. Mr. Mangelsdorf is right about that. Lawyers settle cases by email all the time. But this one was different because Mr. Neal had explained to the plaintiffs that it was going to require a signed settlement release agreement. And what Mr. Neal did after the deadline that he imposed was he pulled the rug out from under that, because he never gave anything to Mr. Lewis other than the proposed January 28 document that gave Mr. Lewis the opportunity and his clients to nail down an agreement by executing a settlement release agreement that was satisfactory to Liberty. That's our case. Thank you.
Thank you, Mr. Winter, Mr. Grooms, and Mr. Mangelsdorf for your arguments. We'll take this matter under advisement.